Hello everybody, this is John DiMartino, Director of Productivity Coaching for the Waxman Group. And in this video, we're going to be discussing the exclusive right of sale listing agreement. Now, as of the recording of this video in September of 2023, this is the most up-to-date revision of this contract. And this is the ERS 18TN, and this was last revised in May of 2020. It's always important to make sure that you're using one, the correct contract, and two, the most recently revised contract. Okay, so now when we will use this contract, this will be when a seller is saying, I'm ready to list my house for sale. I'm ready to hire you. This agreement will spell out what the terms of the sale could possibly look like, what they're requesting, what our relationship is as far as single agency or transaction broker, as well as spelling out the details of the commission and what else is involved with the sale. Okay, so remember that there are a couple different types of contracts as it relates to listing and representation for your buyer. The first one would be single agency. This means we're acting as a fiduciary to our client, and we must disclose that we are working in a single agency relationship. The second is transaction broker, which means you're the middleman of the transaction. And the third is single agent with consent to transaction broker. So essentially, the owner of the property or our buyer, in this case the seller is actually giving us permission in advance to transition to transaction broker if we were to represent both sides of the deal, because we are not allowed to represent both sides in single agency. That's called dual agency and is not legal in the state of Florida. So without further ado, let's jump right into this contract. This is the ERS 18TN, the exclusive right of sale listing agreement. Now, when I meet with a seller, I usually, once I get their buy-in, I usually take on the listing presentation, I'll usually take a blank copy of the contract with me. I'll have some of the line items already pre-filled out, all right? But I usually do not put in the dates, the price, or specific terms in the contract. Okay, I'll go there with either a blank contract or a semi pre-filled out, and then while I'm in front of them, I will break out the pen and I will write in the price and the dates that the listing agreement will be held from. Now, the reason I do that is if I say that the house is going to be one price, and then when I meet with the seller and we're speaking about the different pricing strategies that's available to us, and they say we want to do it to another price, all right, I don't want to have cross-outs and initials and a bunch of different markups on my contract. I prefer and I like a nice clean contract, so that's why I keep that price line pretty blank. Okay, so now if we look on the left side of the contract, we're going to have these numbers. These numbers are page numbers. All right, I'm sorry, line numbers. So if you hear me refer to line number 21, I'm speaking in relation to paragraph 3, line 21, everything that's on the contract from here. Okay, so let's start from the top. We'll work our way down. This is a 5-page contract. The contract is available on DocuSign, Dotloop, Form Simplicity, or wherever you get your contracts from. Again, just make sure we're using the proper and the correct contract, the ERS 18TN. So let's get started. Up here in the very beginning, this is going to be line number 2, and this is going to be the seller's name. Now what we're going to do, we're going to get the seller's name from the tax records, either the seller, the husband's name, the wife's name. If it's in a corporation, we're going to write that corporation up top. Whoever is the legal owner of that property. Sometimes you'll see it where it will say Sally Seller et al., meaning that there's other people that's on that listing agreement, on that own the house as well. All right, and it's important that we write the names as it appears on the tax records on this contract, because we do have to make sure that the right people are signing the contract and giving us authority to sell their home. So if it does have multiple people, I do highly recommend that all the parties that's involved, as far as all the sellers, all right, that they do sign the contract as well. If the husband is there and the wife is there, both of them should sign the contract and initial all the pages. If the husband is there but the wife is not there, I would still get the husband to sign the contract, and then at a later time, either have the the wife or the other party sign electronically, okay, or the next time I see them, making sure that I'm getting them to sign as well. The reason we do this is, one, to make sure that one owner is not trying to sell the property out from under the other person, but the other thing is to make sure that all parties involved are fully aware that this house is listed for sale and have the full buy-in. Even if we do go under contract with a buyer, if one of the parties, let's say the wife, does not agree to the sale of the house, okay, the house cannot actually transfer owners. Both parties do need to sign at closing, or all the owners need to sign at closing. So it's important to make sure we get all the owners to sign up front. So this is going to be the seller's name over on line 2. When we go to the next line, this is the agreement between the seller and the broker. Now, we're not saying this is agreement between the seller and John, the seller and Mike, the seller and Bill. This is the seller and the broker. This is going to be Keller Williams Realty Consultants, Keller Williams Realty Professionals, or Keller Williams Elite Properties, whichever is your designated market center. Okay, so we are putting their name. Remember, when they hire us, they are hiring the broker, and then we are the authorized sales associate for that broker. But the agreement is between the seller and the broker. It's very, very important that we make that distinction. Okay, so let's go down to paragraph 1, or line 4 of the contract. So it's not important to know every single line of the contract, but it is important that you understand the essence of every single paragraph, or the essence of what is meant to be conveyed during for each of the paragraphs. So you don't need to know it verbatim, but understand what is actually in here. But the first paragraph, the authority to sell property, is going to spell out the time frame from when the seller is hiring us until when this contract expires. Typically, you're looking at a 6-month listing term. Okay, there may be some times where you negotiate it to be a 12-month listing term, or for whatever reason you might do a shorter 4-month listing term. Okay, now the start date of the contract is the day they officially hire you. So if they hire you on September 1st, but they tell you, and the seller gives you instructions to not list the house on the MLS until September 15th, well, the listing agreement starts on September 1st, and then later on the in the paragraph for additional terms, this is paragraph 14. And paragraph 14 will say that the seller instructs the broker to not advertise the home on the MLS until September 15th. However, they are officially hiring us on September 1st. So for line 6 right here, we want to make sure we're putting September 1st, or whatever the date that they agree to hire us. Doesn't mean the day we start working, but it means the day they agree to hire us. Again, like I said, I usually like to do 6-month listing terms. And what I usually do is I have all of my agreements expire on the last day of the month. So if it's going to be on January, the month of January when it expires, I'm going to have all my contracts for that month expire on January 31st. It's just a way for me to make it a little bit easier, so I don't have a contract that surprisingly expires on me, which should never happen to begin with, but I don't like any surprises. So that's the dates that the seller has agreed to hire us. Okay, moving on to paragraph 2. This is going to be the description of the property. So there are 2 different addresses for the property. The first is the street address. That's going to be 123 Main Street. And the second address is going to be the legal description. Now, the legal description, we'll find that from the tax records. So you're going to go to your county tax records website, search up the home, and make sure we're putting in the actual legal description. Now, sometimes the legal description is 1 line long. Sometimes it's several pages or several lines long, maybe even a full page long, in which case we're going to click the C attachment. We're going to write attachment A, and on a separate page, we're going to write the entire full listing legal description of that property. Okay, what I have here is a sample of the listing agreement that we're going over. Again, like I said, the legal description is going to come from the tax record, and if it goes any further along longer than what allows on this line, then we can see attachment attachment and put an attachment to the end of this contract. Okay, so line 17, this is going to be personal property that is going to be transferring or conveying to the buyers after the sale of the property. So what else is included? So we got the house, we got the four walls, we have the fixtures, we have the appliances. That is part of this. There's no reason to put in here washer, dryer, refrigerator, because it's already built into the contract by saying the personal property, the property including appliances. So now what is the personal property that is going to transfer? If there's a piano, if it's going to be fully furnished, if there is the movable grill and everything that's on the outside, the pool equipment, this is what I would put in here. That's considered personal property, and I would go ahead and put that over in line 17. Line 19 is the property currently occupied by a tenant? If so, when does that lease term expire? So if it's owner occupied, we're going to say it is not currently occupied by a tenant. If it is tenant occupied, you were going to select yes and then put the date that the lease is expected to expire. Paragraph 3, this is line 22. This is going to be the terms of the contract, the price and terms of the contract that the seller is asking. Okay, again, I leave line 22 blank until I'm meeting with them, at which case, once they say, yes, we want $500,000, that's when I'm going to go ahead and write that into the contract, $500,000. We're also going to next check the terms of the contract, not that the seller wants, where this is the terms of the contract that can qualify for this house. Now, the reason I say that, if we were to turn around and a seller was to say, no, I do not want FHA or I do not want VA buyers for this property, okay, because they might think that it's more stringent inspection requirements, the appraisal comes in lower or whatever. If they say they don't want that, right, but the house does qualify for it, we do have to mark it as we will accept, we'll consider VA or FHA. We don't want to have anyone come back to us and say that this is possible discrimination of a protected status or protected class. Now, the only time I would not check VA or FHA is if this property cannot qualify for VA, FHA, or even conventional, if it won't qualify for any kind of financing whatsoever. For whatever reason, if I know that this house will not qualify, I'm not going to mark it there. But if it will qualify, or if it could qualify, I'm going to mark all the terms that are necessary. So cash, conventional, VA, or FHA. The next term it goes into is asking about seller financing or assumption. Seller financing and assumption of an existing mortgage, that's a different animal, and that's a little bit more advanced than this video. So I'm not going to get into the details for this particular video. If your seller is interested in doing seller financing, contact your coach, contact your broker to find out what the terms of how we do that. Contact legal counsel to find out how we can do that. There's certain verbiage that should be in there, and that's not a normal everyday occurrence. Okay, so we're going to go down to paragraph 3C or line 37 for seller expenses. This says that the seller will pay mortgage discount costs or other closing costs not to exceed a set amount of the purchase price for the buyer. Usually what I write in here is zero. This is saying that I'm stipulating from the very beginning up front that we are not obligated to pay any of the closing costs for the buyer. However, I do have the conversation with all of my sellers when we're putting this together. I do let them know that there may be a case where the buyer is very well qualified. This is a great buyer. This is a great offer, a great contract, and a great price. However, they're short $5,000. They're short $10,000 for closing costs. All right. In which case, we're going to go through and negotiate. We're going to negotiate a closing cost or a possible seller credit. All right, as long as the net number works out for the seller. Okay, but however, that's going to happen once we have a contract or an offer on the table. We don't have that right now. All right, so I'm stipulating, or I'm putting from the very beginning, that it's going to be 0% of the purchase price. We're not obligated to make any seller contributions towards the buyer's closing costs. Okay, so as we continue on, paragraph 5 and paragraph 6, this is saying that we're going to be putting the home in the MLS, in the multiple listing service. And as we put the home in the multiple listing service, they have rules. The MLS and the local board and association has rules that we have to abide by, but we will be putting the home in the multiple listing service. Paragraph 6, and in fact, this entire page talks about what the broker authority is, right? What the seller is authorizing us to do, as well as what the seller obligations are. What are they? What did they agree to do? And we're putting these agreements at the very, very beginning. Okay, so in paragraph 6A. All right, this is saying that we're going to be taking your home and we're going to be putting it on the internet. We're going to be advertising it aggressively. Okay, now there are 2 different lines over here, and this is going to be this is going to be line 58 and 60. This is saying that the seller does not want us to advertise their property on the internet, or the seller does not want us to go on to use their address or advertise on the MLS. If for some reason they do say that, okay, that is the only time that they would have to initial right over here. Now, I'm sure there are a couple different instances in which that would be the case, where they would say, do not advertise our home on the internet or in the MLS. But for the most part, 99 times out of 100, we are not going to complete or sign this section. This is going to be paragraph 6A and paragraph 6B. Okay, as we continue to go down, paragraph 6E, this is saying that the seller is giving us permission to put a lockbox on their door. Now, there's combination lockboxes. There are super lockbox, which is the electronic lockbox. That is the one that I would recommend, the super lockbox, because the combination lockbox, anybody can get that combination. A buyer's agent can give their client the combination, and they'll now have free access to the home, which we don't want. The super lockbox gives the most amount of security for the homeowner. So if a homeowner says, I do not want a lockbox on my house, I don't want any, Tom, Dick, and Harry being able to enter my house, explain to them that the only people that will have access to the lockbox is people who have a confirmed appointment and people that are licensed and active real estate agents. It checks it every single time. Right before they open, they check to make sure that there's still an active Supra subscription and authorization to grant access. Okay. I also put on here withhold verbal offers. All right. The reason I say withhold verbal offers is there's no such thing as a verbal offer. So someone says, hey, John, will your buyer be willing to accept $500,000 on this house, a $500,000 offer? I'm going to tell them to put it in writing and send me an offer. Well, let me know. Will they accept it? My sellers have instructed me to not accept any verbal offers, put it in writing and send it over to me. Okay, so I do make sure that I check this first one about withhold verbal offers. The second checkbox I do not check. This is withhold all offers once we accept a sales contract. Now, I'm a firm believer in once we accept a contract to continue to market it in order to try to get backup offers. If we check this other box, then we are not allowed to continue to market it and collect backup offers. That's why I keep this one unchecked. Okay, as far as for paragraph 6G, this is going to be line 80 and 82. Okay, this is saying when this is referring to virtual office websites, this might be a valuation site, and the first one says that the seller does not authorize an automatic estimate of market value of their home. I do not check that. All right, that's going to be your Zestimate. That's going to be your Redfin or your Realtor.com estimate. I don't usually check that. Okay. I also, however, I do check that I do the second box where it says the seller does not authorize third parties to write comments or reviews about the property. If someone has nothing to say about the property good, I don't want them saying anything at all. That way, so by unchecking that, I'm not allowing them, the seller is not allowing, is not authorizing them to write comments onto the listing. So we're going to leave the first one unchecked and the second one checked. So that is what the seller is giving us the authority to do. List the house, market the house, sell the house, show the house. Now, what is the seller's obligations through all of this? And this is going to be in paragraph 7, starting on line 84. So in consideration of us hiring us, the seller agrees to cooperate with us on almost everything when it comes to the home. So letting us know if there's anything anything material about the property that is not visibly seen. So this is going to be a seller's disclosure. This isn't say cooperate with showings. This is say give us keys to the home so that we can show the home. And if you're going to be mortgaging the home, refinancing the home, leasing it out, or doing anything else, taking out another mortgage, taking out another loan, doing anything that could encumber the property to be sold, to let us know. Okay. Also, if there is any losses that the broker and the sales associate there's a hold harmless for any kind of losses, damages, costs, or as it results. This is going to be on paragraph 7. I do write in here, we did mention this, make all legally required disclosures, including facts that materially affect the property value that's not readily observable. So I actually put in here, see seller's property disclosure. Once they sign the listing agreement, I do give them a blank seller's disclosure for them to fill out. We are not allowed to fill that out, so I do want them to fill that out. This is going to be yes, no, or I don't know answers to this list of questions. Sometimes a seller will say, well, we did have a leak 3-4 years ago, but we fixed it. I'd rather not disclose it because I don't want anyone to think that there's something wrong with the property. And that's really bad advice. What I would recommend to them is, we live in a very, very litigious time where everyone has their attorney on retainer and they're always looking to point blame at somebody. So we get to, by disclosing the fact that there was a leak 3-4 years ago, however, it's been properly fixed and has not been leaking since, we are kind of absolving ourselves from, there was a leak and you just didn't tell us. No, we told you. It was in the seller's disclosure. All right. In fact, the buyer actually signed that. All right. So it is very important that we have a seller's property disclosure for every one of our listings. As we go down to paragraph 8, this is talking about compensation and commission. Now, I'm going to tell you what I do when I'm preparing this. All right. When I'm preparing this, I said that I don't put in the price or the date. What I do put in here is my commission. I'm putting in here 6%. I'm saying that my total commission that's going to be earned on this sale is 6% of the purchase price plus $395 transaction coordination fee. You may choose to charge more for a transaction coordination fee. You may choose less for a transaction fee, and that's completely up to you and your broker. However, National Association of Realtors says if we are charging anything above that's not considered direct commission, we do have to make sure we're giving them something. We can't just make up an arbitrary number and say, I'm going to charge you $1,000 extra without explaining what that buyer gets for that $1,000. So what I do for my business and all my listings, I go 6% plus a $395 transaction coordination fee. And then I explain what that $395 is to the client. I explain to them that we have a transaction coordinator that will manage the contract from contract all the way to close. She's going to be the main point of contact to make sure that everything is completed, that everyone's on the same page, that dates are being met, that there's no initials that were missed. She charges us $395 and we charge you $395 on the closing statement. If the deal does not close for whatever reason, my transaction coordinator doesn't get paid, I don't get paid, nobody gets charged at $395. The commission is only earned once we actually bring a buyer, we have a meeting of the minds, we all agree to it, and then we're able to get towards a closing. As far as the commission being 6%, what ends up happening typically is we say 6% is the total commission. This is how much we charge to list your home. Of that 6%, half of that, or 3%, is going to be going towards compensation. Now, you may say to yourself, well, you know what? I'm doing a lot more work on this deal. I should get 3.5%, while the buyer's agent gets 2.5%. If that's what you choose to do for your business, that's completely up to you. Just know that at closing, all the agents are going to be able to see what commission percentage of commission was given to the seller's agent, what percentage was given to the buyer's agent. The way I see it is, if I'm collecting full 6% commission, I'm splitting half of that with the buyer's agent. Okay. Now, I do pre-fill in the 6% plus $395 because I'm going into my listing presentation not expecting to have to negotiate that. My fee is 6% plus $395. Now, I'm not saying that I will not negotiate that. I'm saying I'm not going in there planning on negotiating it. So I do put that in. Now, when I get there, if we do decide to renegotiate a lower commission, whether it's 5% or 5.5%, at that time, when I'm sitting in front of them, when they're about to put pen to paper and officially sign this listing agreement and hire me, at that time, I will cross out the 6. I will write the 5.5 or 5% or whatever I agree to. And then we're going to have myself, as well as the other agents, the sellers, will also sign that, acknowledging that we've made a change to the contract. This paragraph 8B. Okay, paragraph 8B is if there's going to be an option, which most of the time we're not using, so we're going to leave this blank. If your seller says that they are interested in doing an option, that's going to be something above and beyond the normal contract, and not outside of the scope of this video. At that time, contact your broker, contact legal counsel, contact your coach, and we'll discuss that at that time. Okay, if they're going to be leasing the property. Okay, now there's a separate listing agreement for lease. However, sometimes they'll say, I'm okay with selling or leasing it. If so, we could put what that percentage is that we're agreeing to sell the house for, or rent the house for, lease the house. You might say 10% of the gross lease value is how much that we're going to get paid. In that case, we're going to put that here on paragraph 8C. If they're saying they're not doing an option, they're not planning on leasing, they just want to sell the property, a regular arm's length sale, we're going to put the commission over on paragraph A. We're going to put the transaction coordinator fee. If we're charging that, we're going to leave 8B and 8C, we're going to leave that blank. Okay, paragraph 8D, this explains when is commission due. Okay, so when is commission due? If any interest of the property is transferred, whether the buyer is secured by the seller or not, or the broker or anybody else, commission is due. So if I have it listed, but the seller tells his friend at work, and his friend at work is the one that comes and buys the house, commission is still due. If I'm doing an open house and someone just walks into my open house, commission is still due at that time. All right. If the seller refuses or fails to sign an offer that meets the price and the terms stated in this agreement, well, then the seller technically defaults on this contract, and commission is due. Okay. We also have a protection period built into this contract. So if I said January 31st that the property, this contract expires, however, the seller decides to sell the property on February 10th to anybody. Maybe it was, he's selling it without a real estate agent. He's just doing it for sale by owner. He did his own open house, or it was someone that we brought to originally. All right. 180 days after the termination date, right? Commission is still due if they go ahead and contracts to sell the property to anybody else. However, and this is going to be on line 125, and this is important. However, no commission will be due if it's relisted after this contract expires and relisted with another realtor. So They're listed with Keller Williams up until February 1st or January 31st. On February 1st, they decide to list with RE/MAX, and then on February 2nd, it sells using the RE/MAX agent. No commission is due to Keller Williams, okay, because of that line 125 and 126. The next paragraph, paragraph 8E, is going to refer to retained deposits. So if a deal falls through, let's say the week before closing or a couple days before closing, the buyer says, I'm out, I don't want to do this anymore, I'm going to just go ahead and cancel the deal. The seller can then, depending on the contract, the seller may be eligible to retain the buyer's deposit. Okay, and this paragraph, this subparagraph says if you receive a buyer deposit, this is how much the broker or Keller Williams is entitled to keep of that. Now, by default, it says 50% of any deposits retained will go to the broker, not to exceed the total commission amount. So if we're only expected to receive $15,000 in commission, okay, and the deposit is, $50,000, well, the most we'll be able to retain is $15,000. Now, that's by default. My business practice, what I do is I choose to write 0 in there, meaning if there is retained deposits that the seller is able to keep, I shouldn't receive any money from that. The damages should belong to the seller. That is my personal that's my personal opinion, but it's up to you if you want to leave it at the 50% or you want to change it to 0%. If I do it at 0%, I do point it out to the owner that by default, most people will charge 50% there. We're charging 0. Paragraph 9, this is me on line 130. This is going to go down to what we were speaking about earlier of commission is 6%, and I'm sharing half of that with the buyer's agent. So this is us letting them know up front in the very beginning that of the commission, okay, that we will pay 3% of the purchase price, all right, to someone who's working as a single agent for the buyer. We'll also be willing to pay 3% of the purchase price if they're representing a transaction, if they're being represented as a transaction broker for the buyer. I also choose not to check this final box, right? Which this says if the broker has no brokerage relationship with that buyer, well, I'm not paying them anything. Okay, because chances are I'm going to end up doing a lot of the work anyhow, since I'm representing, chances are I'm going to be working more and representing both sides of that deal anyhow. But what I do, I usually check the first box for single agent, and I'm willing to pay the second box, pay a transaction broker. Okay. Now, one of the other things in here, the office policy is to cooperate with all other brokers except when it's not in the seller's best interest. Okay. Again, if you feel that it's not in the best interest, contact your broker, contact your coach, contact legal counsel to find out what's the best way to negotiate that. Okay, as we go down to paragraph 10, this is going to be describing what the brokerage relationship is. Now, our broker prefers that we work in what's called single agency. Remember, this is acting as a fiduciary to the client by dealing honestly and fairly with them, full loyalty, full confidentiality, full obedience, full disclosure, accounting for all funds, skill, care, and diligence of the transaction, presenting all offers and counteroffers in a timely manner, okay, unless the seller has given otherwise, and disclosing all known facts that materially affect the value of the property that are not readily observable. We are working for them in their best interest. That is how we choose to work in our brokerage. If we are working for them as a single agent, they do have to sign that they are acknowledged that we're working for them as a fiduciary. Now, the only time that we break from that is if we're representing both sides of the transaction. All right. At this point, they're going to give us permission to transition to transaction brokerage, which is a limited form of representation for both parties. So even though I'm working as a single agent for my seller and I'm working for a single agent for all of my buyers, if we're going to be working together on the same transaction, I cannot be a fiduciary for the seller and the buyer at the same time. At that point, we will transition to transaction brokerage. Dealing honestly and fairly, that's still the same. Still have to use skill, care, and due diligence and account for all funds. And we still have a legal obligation to disclose all known facts about the property and present all offers in a timely manner. However, the biggest difference is going to be right here. Is going to be number 6, line 173. It's limited confidentiality. And this is limited confidentiality. Remember, as a single agent, we have full confidentiality. Now, limited confidentiality, what that means is anything that's learned while in single agency will still remain fully confidential. However, we're not obligated, all right, we're not obligated to disclose every single thing that we know about the other person's situation, because that would be acting as a fiduciary, and since we're transaction brokerage now, it's limited confidentiality. Okay, they're going to give us permission up front, and they're going to sign lines 183 at that point as well, just giving us the permission to transition if we need to. Okay. If you have other questions about the difference between being a fiduciary or a functionary or single agency versus a transaction broker, speak to your broker, speak more in detail for you. Okay, paragraph 11. This is going to be the termination, the conditional termination. At the seller's request, the broker may agree to conditionally terminate the agreement. So the seller says, "I don't want to list my house anymore. I want to cancel this contract." Absolutely, we 100% can agree to conditionally terminate. Now, what we say is, if we can terminate, but there may be a cancellation fee of blank. I personally, for my business, choose 0% or $0 cancellation fee. I do not charge any cancellation fee. However, all right, what we may charge, the seller may still be responsible for any kind of reasonable marketing expenses that were incurred during that time. If you have any questions about that, contact your broker, contact your coach, and they'll be able to explain what that might look like. But for the most part, I'm telling them that I do not charge a cancellation fee. I do let the buyers, the sellers know that there's an easy out agreement built into this contract, where if I'm not doing what I said I was going to do, you can go ahead and cancel this listing agreement, no questions asked. Okay, and I do not charge a cancellation fee. Now, I'm not saying that I'm not going to charge them for my marketing expenses. I'm just saying that there's no cancellation fee that is in there. Okay, paragraph 12, this is line 194, the dispute resolution. Okay, so if there's a dispute on anything that happens with the seller, the answer should be written into this contract. Okay, this contract is what is going to be the deciding factor of most of the disagreements or disputes that we'll have during the sale. If for some reason that we cannot come to an agreement and we're still having the seller and the owner are still the seller and the broker are still in dispute, then we can either go to mediation. All right. And if that cannot, if mediation does not work, all right, the next option would be to go to arbitration and then to court. Now, our broker does not authorize us to go to arbitration. He's saying we're going to go to mediation, skipping arbitration and going to court. The reason why is mediation is an opportunity for us and the sellers to work something out together. If we go to court, this is a judge who is fully fully versed in the law, fully versed in contract disputes like this. He's going to make a judgment that is going to be binding, all right, which is good. However, in arbitration, you're not having a judge. However, the decision that the person in charge of the arbitration, that decision is binding. So our broker says we will not go to arbitration. We do not sign this section. The seller does not sign this section. And for some reason, if the seller did say, yes, I absolutely want to go to arbitration, well, then the seller has to sign, the sales associate has signed, and this is the only line that the broker also has to sign. Okay, so for the most part, we are not going to sign this section as well. Okay, paragraph 14. This is going to be any additional terms that the seller is instructing the broker, the seller is requesting. That additional terms will go into here. So the seller instructs the broker to not put the home on the MLS until September 15th. The seller agrees to not show the home after 5 or before 5 p.m. Monday through Friday. Whatever that the seller also wants is instructing us to do, we're going to put that here in paragraph 14. These other two paragraphs that I put in here is a best practice. It's not mandatory. Our broker does not require this. However, this is a best practice that I recommend, and this is what I do put into all of my listing agreements. The seller requests that all financed buyers obtain a pre-qualification from Supreme Lending. Supreme Lending is obviously our preferred lending partner. All right, your broker or your market center may have another relationship, but if you have a lender that you and your seller absolutely trust, it's requested that all finance buyers obtain a pre-qualification from them. The buyer is not obligated to use Supreme Lending or whichever lender you choose. They're not obligated to use them for financing. I just want to make sure that if ABC Lending is writing a pre-approval letter, I don't know what they did in order to, what ABC Lending did in order to obtain that pre-qualification letter. I'm going to have our lenders take a look at his financing, take a look at his income, his expenses, and everything to see, can this work? Can this deal work? I'm going to have our lender do at least another once over the buyer's financing ability. Additionally, I put in here that the seller requests that Title Alliance Professionals of Florida or whoever your preferred title company is. All right. Seller requests that Title Alliance Professionals is used as the escrow agent and closing agent for this transaction. Seller is aware that it is customary that the party that selects the closing agent usually pays for the title insurance policy. So in Broward and Dade County, it is customary. It doesn't mean it's mandatory. It doesn't mean it's every single time, but it's customary in Broward and Dade County that the buyer picks the title company. Now, the person that picks pays for the title policy. So in Broward and Dade, the buyer picks, the buyer pays for the title policy. In Palm Beach County and most of the rest of the state of Florida, the seller is the person that chooses the title company. And if they choose the title company or they choose the closing agent, they're the ones responsible for paying the title policy. So think of it like the buyer, whoever picks pays. So buyer picks and pays in Broward and Dade, seller picks and pays in Palm Beach and the rest of Florida. Now, what I'm saying in here is I'm having the seller requesting that we still control who is the title company or who's the closing agent for this property. Even if this is in Broward County where the buyer typically picks and pays, we're saying it's perfectly fine that that the buyer picks the title company. I just want the buyer to pick Title Alliance, and we can work that in as part of the negotiation. Or the seller may turn around and say, no, I absolutely require them to use Title Alliance. I'm fine with paying for it. Then that's exactly what it's going to be. That's part of the negotiation as well. The reason I like putting these two things in here is most deals are going to fall apart either in the inspection period, when it comes to financing, or when it comes to title. So if I, as the seller, can control as many of the moving pieces as possible, and that's going to be with the lender and the title company, well, you know what? I at least feel comfortable that 2 of the 3 things that usually will cause a deal to fall apart, those are under my control, and or at least with the company that I know, I'm familiar with, and I trust, and I feel better about that deal making it to the closing table. These 2 terms are all about bulletproofing the transaction. Okay. Now at the very end, we're going to have the seller sign. All right. The seller is going to sign line 227. They're going to sign line 231. If there's another seller, we can have them just sign next to it as well. But this is where the sellers are going to sign. Us as the authorized sales associate right here also have to sign. We don't necessarily have to have our broker sign it, because our broker has given us the authority to sign listing agreements on his behalf. Once we do that, it is important to make sure that we put the contact information. This is so everyone knows how to get in touch with each other. All right. So the telephone number, email address, property address, as well as the brokerage firm name and our address and how they can get in touch with us. Now, this last box, line 238, there's a reason why line 238 is outlined in a separate black box. All right. If this contract is fully filled out and it's fully signed and everything is good to go, however, we did not return a copy of the signed agreement back to the seller, all right, then it is considered to be avoided. So once the buyer and all the parties sign and initial everything, we do have to make sure we put in here that the date that the contract was returned and how it was returned. If it was by DocuSign or .loop, they're going to get a signed copy via email. Okay, but if you're going to be giving them a handwritten personal delivery, I would still recommend that if they're receiving the contract, that they're going to initial off to the side acknowledging that they did receive it. So where do we sign? We sign right over, remember, right over here, seller sign, the broker sign. And at the bottom of every page, the seller is going to need to initial and the sales associate is going to initial right over here. And you'll see that on every page. Aside from that, if there's any changes to the contract or if they decide they want to strike through any of the terms of this contract, they'll be able to initial next to those changes as well. Again, once we prepare this, we have the seller sign. All right, we give them a copy of it either by email or personal delivery. This is now a valid and enforceable contract. It's no longer this is now a valid and enforceable contract. And anything, if there's any disputes, it's going to be based on the terms that has already been pre-agreed within the contract. If you have any questions about anything that's changing or changing any of the terms from this contract, contact your broker, contact your coach. Someone will be able to assist you. If you have any further questions about this, contact us at any time and we'll be able to walk you through this part of the transaction. Congratulations on getting your first listing. Make it a great day.